On this basis, the preliminary objection ought to be dismissed, and the prayers sought in the complaint ought to be granted with costs. Honorable Chair and members, I thank you for your time listening to me, and I shall be happy to take the submissions and reply before I make my final reply.
Thank you, Mr. Kero. You've actually kept within time.
Thank you, Madam Your Honor.
Mr. McFall.
Yes, Chair, thank you. We will distribute our submissions among the advocates in the following manner. I will go first. We'll take about 12 minutes. My colleague, Mr. Mondi, will follow. He will take about 10 minutes. And our senior, Honorable TJ Kajwang, will close. By listing down the documents that we have filed in support of our defense against this claim. We filed, Chair, a replying affidavit dated the 21st of February 2026, which is accompanied by a letter of authority of the same date. We filed a preliminary objection dated the 20th of February 2026. Thirdly, a certificate of electronic evidence, which we filed together with digital evidence, copies of which were supplied to both counsel and to the tribunal. We filed a case digest and list of authorities dated the 25th of February 2026. And finally, Chair and members, we filed submission.
Mr. Magoli, sorry, you're doing me too fast. You filed a certificate of electronic evidence dated?
The certificate of electronic evidence is dated the 25th of February 2026.
Then?
Case digest and list of authorities dated the 25th of February 2026. And finally, written submissions, Chair, filed on the 10th of March 2026.
Okay.
Chair, I've been listening closely to my learned senior, S.C. Okero, and I would like to start by addressing the issue of jurisdiction. It's the first issue we're addressing, whether this Honorable Tribunal has jurisdiction. In his submissions, my learned senior made reference to and posed a question as to who is the aggrieved party in this case. And interestingly, the suggestion made by my senior was that the neck of the ODM party is the aggrieved party. I would wish to invite the tribunal to have a look at paragraph 4 and paragraph 12 of the statement of claim that is filed in this case. Paragraph 12 in particular contains the course of action, because it is common knowledge that every pleading that originates a suit must have a course of action. The course of action, as contained in paragraph 12, followed by 13, relates to the meeting held by the NEC on 11th of February 2026 and the resolution that followed. That resolution is why we are before this tribunal. If you also look at the prayers, which are, and specifically prayer 1, the complainant seeks to have a declaration that that resolution be declared to be null and void. So therefore, it beats all logic to try and suggest that the NEC is the complainant or the aggrieved party for that matter. Having settled that issue, Chair, in our appeal, we are basically stating that there was non-compliance with Section 42A of the Political Parties Act. It's a well-known section. It has been litigated all the way to the Court of Appeal. And Section 42 and subsection A, as amended in 2022, clearly provides that the tribunal shall not hear or determine a dispute unless a party to the dispute adduces evidence of an attempt to subject the dispute to internal political party dispute resolution mechanisms. The key word is an attempt. And from the submissions that I've had this morning, coupled with the pleadings filed, it is very clear that there was no attempt. In actual fact, paragraph 15 of the affidavit in support of the complaint all to invoke IDRM. There are a whole list of authorities that have been rendered in respect of that issue. I would wish to invite the tribunal to have a look at a case digest. Authority 2, 3, and 4 speak to the issue of an attempt. And in particular, the second authority, which was decided by this tribunal, Chabere and 15 others, plus the national chair, ODM, this tribunal held very clearly that the amendment that was made in 2022 was made to enhance party harmony and cohesion. It was therefore imperative for this complainant to demonstrate that he made an attempt. And in making an attempt, it does not mean that that attempt has to be considered. That is why that proviso was put in place. So we submit that there is no demonstration of an attempt. We go further to address the issue of whether or not NEC was the final port of call within the party. It was suggested by my learned senior that there was no follow-through once NEC made a decision. I wish to invite the tribunal to have a look at Article 88 of the ODM Constitution.
Article 88.
Yes, 88.
88.
Yes, that article, Chair and members, clearly provides for amicable dispute resolution. And even further, it goes on to say that any dispute that cannot be resolved by party organs shall be adjudicated through arbitration. So in the first instance, members of the party and members with the party organs are encouraged to do IDRM, but where that fails, there's even the process provided for arbitration. The claimants did not pursue the provisos of Article 88, and therefore it cannot be hard to say that there was no room for him to initiate or to follow through on IDRM. There is a recent decision that was delivered by this tribunal on the issue of attempt. It was delivered in November of last year. That is Harrison Abo versus Nicholas Otieno Owaka. And the tribunal was very clear that there's no room for the tribunal to exercise any discretion once it is satisfied that there's no attempt at IDRM. So, Chair, we submit on that issue that there's been no attempt at IDRM. The law is clear. The issue of jurisdiction is settled, going as far back as the case of Lillian S. And we therefore submit that the preliminary objection should stand, and this claim should be dismissed for want of jurisdiction. Chair, in the remaining minutes I have, I'll go to the second issue, which will then be amplified by my colleague, Mr. Mondi, on whether the rights of the complainant were infringed and whether Article 74 of the ODM Constitution was violated. Chair, I would wish to invite the tribunal to go to the claimant's own document at page 82. Starting from page 80, we find the resolution by the NEC. That is why the reason why we are before this tribunal. In an SMS message that was sent via WhatsApp, the agenda was set out for that meeting, and as part of the agenda, it was indicated that there would be a discussion on matters arising. When you look at page 81 of the complainants bundle, under resolution number 6, the issue of the removal of the Secretary General came under matters arising, which was part of the agenda. It is also important to mention that the SG was given full opportunity to attend that meeting. He chose not to. And in the replying affidavit that we filed at paragraph 5, that is the affidavit of Ali Madaro, we clearly indicate that the resolution of the NEC was subject to the provisions of the party constitution. And that is what the resolution also says. So that our argument remains that under Article 74(3), the complainant had the right to be heard. That right could not be exercised because the complainant rushed to this tribunal, essentially on the same day that that resolution was passed. So we have an instance where chair and members, the complainant does not attempt IDRM at all and admits to it in his pleadings. We have a situation where Article 88 of the ODM Constitution provides clearly for IDRM and also an alternative process of arbitration. We have an assertion made in the replying affidavit that the complainant was to be afforded an opportunity to defend himself. He, however, rushed to this particular tribunal. So in sum, as I close on my arguments, we argue that no final decision had crystallized.